You can find all of the platforms I'm on in the link in the bio. And of course, I'm available for a private discussion one-on-one with you. If you don't or can't pay the $47 for the discovery session, then talk to me and I offer like full ride scholarships all of the time. So what's more important is more people knowing than me making almost $50. Okay. So that's the main thing. However, I do need to pay rent and stuff like that, and so they don't like people like me, and so they make it very difficult. So also, if you know how to fund a private ecclesiastical ministry without doing like grassroots bootstrapping, which is what I'm doing, let me know, right? I know that I can make an LLC and, get funding that way. I don't know how to do all that. So if you know how to do all that, it's cool. Let me know. We're talking about the unlawful nature of these proceedings, these charging instruments. If you cannot provide me such documentation of a contract, well, then I respectfully demand that you allow me to inspect and verify the affidavit in support of a warrant and a bona fide warrant authorizing my arrest and the loss of my property. So I respectfully demand that the aforementioned warrant demonstrate that it was created and issued within 48 hours of the seizure of my person and my property in accordance with County of Riverside versus McLaughlin. That's a decision from the Supreme Court made in 1991, and Gerstein versus Pugh, which was a decision made in 1975, essentially requiring that within 48 hours of arrest or the seizure of your person or your property, you must have a warrant given to you. Now, what happened with me, they took me into jail, and I was sitting there for 4 hours, roughly, somewhere in there, right? And then they let me go because I bailed myself out, okay? But you saw for yourself, they still didn't do it right. So yeah, they gave me a warrant, they didn't do it right. Okay, and you'll see why they didn't do it right, because here's subsection B of this affidavit that I use to teach my clients, anyhow, which was given to me by my mentor. I further demand that the aforementioned warrant be a written order signed and sealed by court officers, and that it includes an application for a warrant supported by a sworn and detailed statement made by a law enforcement officer appearing before a neutral and detached judge or magistrate or civil officer of the United States in accordance with Mincy versus Arizona. That was a decision made in 1978. Rubber stamp or electrical filed signatures are null and void in accordance with State versus Pollock, which was a decision made in Minnesota in 1967. We have got some United States Supreme Court decisions. We've got a Supreme Court decision out of Minnesota, some of the points of authorities. I'm happy to go through this with you a little bit more in detail in the future, okay? But for right now, we're just going to keep on cruising. So I further demand to comply with the Fourth Amendment restrictions, any anticipatory search warrant clearly, expressly, and narrowly specifying the triggering event either on its face or on the face of the accompanying affidavit. Seizures executed after illegal trespass are invalid under the Fourth Amendment, in accordance with United States versus Hotal, a decision made in 1998. So again, if they pull you over like they pulled me over, and they put you in handcuffs and they take you to jail and they haul they tow your vehicle away, right? We can ask for the valid warrant which allowed them to do such. And then they take it and they haul it and they start to rifle through all of your things. There have been irreplaceable family heirlooms that I permanently lost, all because I did not go along with their extortion activity.